Hi, I'm Emma, an associate in the Commercial IP and Technology team here at Travers Smith, and today I'll be giving a brief overview of the impact of Brexit on dispute resolution as part of our Brexit video series. In this video, we will consider the impact of Brexit on governing law, jurisdiction and enforcement, but please do refer to our dispute resolution team's briefing note on our website for further detail on the impact of Brexit on cross-border disputes. So to start with, the position before the end of the transition period was that the UK was part of an EU-wide regime that provided a set of common rules on governing law, jurisdiction, enforcement, and service of process. We're now outside of that regime, but what does that actually mean in practice? Firstly, on governing law, the upshot is that there is no real substantive change. This is because the UK has decided to continue applying the same rules as before, even though it's no longer subject to the EU regime. But when it comes to jurisdiction and enforcement, there is more of an impact. This is because being inside the EU regime meant that there was near automatic recognition by the courts in the EU of English court judgments and contractual clauses conferring jurisdiction on the English courts. Since Brexit, however, there is now a higher risk that a dispute involving a counterparty in the EU will get tied up in arguments about which court takes jurisdiction or whether, when it comes to enforcement, the EU court will recognise a judgment from an English court. There is an important exception to this in the form of the 2005 Hague Convention, which I'll come on to in a minute. The final piece of the picture on dispute resolution is service of process, which has also become somewhat more difficult after Brexit. However, various unilateral actions by the UK does mean that it's less of an issue where you have an English jurisdiction clause, whether this is exclusive or non-exclusive. So that's a very high-level summary of where we are, but what should you actually do in response to these changes? When it comes to contracts which we're entering into now, it's worth bearing in mind that if you opt for an exclusive jurisdiction clause, then the 2005 Hague Convention may assist. Where it applies, the upshot is that you can largely maintain the benefits of near automatic recognition, both of the jurisdiction clause itself and any English judgment relating to a contract containing such a clause. But I use the word may here because there are a number of respects in which the 2005 Convention isn't quite the same as the pre-Brexit regime. For example, it doesn't apply to insolvency or certain company law matters, nor does it apply to consumer or employment contracts. And both the EU and UK have chosen not to apply it to insurance contracts. So whilst it's helpful, it doesn't fix everything. If the Hague Convention doesn't apply, then it may be worth considering alternatives. For example, both the EU and UK remain signatories to the 1958 New York Convention on the Recognition of Arbitral Awards. So a clause providing for arbitration will be respected, as will any resulting award. But arbitration won't always be suitable. For example, if you're in a contractual chain and you want to be able to join third parties, such as suppliers or subcontractors in the event of a dispute, then litigation may be preferable. So the key takeaway here is that whilst it may be worth changing your approach to dispute resolution, where there's an EU company and a particular concern about enforcement, there are plenty of other issues to consider, some of which may ultimately be more important to you than trying to compensate for any potential difficulties caused by Brexit. It's also worth thinking about including an agent for service clause, although, as mentioned previously, this may be somewhat less of a concern where you already have an English jurisdiction clause. As for contracts entered into before the end of the transition period, there really isn't much you can do about these if you're not able to secure a variation to the dispute resolution mechanism, or if it's an exclusive jurisdiction clause, enter into an agreement with the counterparty expressly reaffirming it. In terms of how the UK can resolve some of these post-Brexit difficulties, whilst it would have been helpful for the UK to join the Lugano Convention, the EU has effectively blocked the UK's attempts to do so, largely on the basis that it's only suitable for countries within the single market. So currently, the only viable route for the UK to improve the situation on dispute resolution looks to be the 2019 Hague Judgments Convention, which neither the UK nor the EU have yet acceded to. But it's hoped that they will, which could then provide a basis for improved recognition of English court judgments in the future. So to summarise, the key point is to be aware of the impact of Brexit on the recognition and enforcement of dispute resolution clauses if you're either drafting new contracts or heading for a dispute, as it may well affect how you decide to proceed. This is part of a series of short videos on different aspects of the UK's post-Brexit arrangements, so do check those out if you're interested. A link to the briefing I mentioned earlier, which contains further detail on this topic, will appear at the end of the video. Thanks for listening.